Good evening, my name is Roland Orange. Together with my colleague Ms. Urbanova from the Corax Foundation, we'll have another match from the day 2. This is still the group phase for the EST Inter-University Law Debate Tournament. So I give the floor to my colleague.
Thank you very much. My name is Anna Maria Urbanova. I'm co-director of Corax Foundation, and together with my colleague, we'll be hosting today's match. So today we welcome the debaters from University of Manitoba, joining us from Winnipeg, and debaters of Tallinn University of Technology, joining us from Tallinn in Estonia. The debate statement that the teams received 7 days in advance is that arbitration offers a more efficient and impartial alternative to lengthy and costly state-to-state dispute resolutions. So the teams had 7 days to prepare for both positions. We'll know by randomizer which position will be defended by which team. But before we get to that part, it's time to discover a bit more about our debaters today, starting with University of Manitoba. Mr. Harris, the floor is yours.
Hello, everyone. Thank you, organizers, judges, viewers, for having me here today. It's a pleasure to be here and to speak with you, and it's a wonderful opportunity, and I'm very happy to meet my colleagues from the Tallinn University as well. My name is Samir Harris. I forgot to introduce myself, and I'm a first-year law student.
Thank you and welcome. From Tallinn University of Technology, Ms. Rikacheva, the floor is yours.
Hello, my name is Ksenia Rukacheva, and I am a final year bachelor student of International European Law here at Tallinn University of Technology in Tallinn. I'm really excited to debate. Thank you.
Thank you and welcome from University of Manitoba, Ms. Andrews.
Hi, everybody. Good afternoon to us and good evening to our colleagues in Estonia. Very excited to be here, and thank you to the Corax Foundation for hosting and facilitating all of this. My name is Tia Andrews, and I am a first-year law student at the University of Manitoba.
Thank you and welcome from Tallinn University of Technology, Ms. Gold.
Hello, everyone. My name is Fabian Balle. I am the first-year bachelor student here in law and international and European law, and I'm very, very excited for this debate.
Thank you very much. From University of Manitoba, completing your team, Mr. Bullard.
Thank you. My name is Kirat Bueller. I'm a first-year law student as well at the University of Manitoba. I'm really excited for the opportunity to debate against our friends from Estonia here and for everyone watching. Thanks.
Thank you and welcome. Today we also have on the call present one of the coaches for the teams. So University of Manitoba is coached by Ms. Diana Gutierrez, who's also a past participant of the Hague Inter-University Law Debate Tournament, representing her university in past edition. And Tallinn University is coached by Mr. Alexei Oskander Johannes, who's not currently present with us on the call, I believe. So I'll give the floor to Ms. Gutierrez for some introduction.
Hello, everyone. It's really exciting to be here again this year, but on the coaching side. So I've definitely been where you all are today. So kudos for participating in what is about to be a wonderful, wonderful experience. So good luck to all of the participants today and enjoy your time during all of these debates.
Thank you very much and welcome again. In a short while, you'll see the randomizer to allocate your positions for today's match. So if you could just please give me an audio confirmation that you can see my screen.
Yes.
Yeah, we can see it.
Yeah.
Thank you very much. So in a short while, we will know the positions for today's match. All right, so for today's match, the University of Manitoba will be defending position in favor, and the Tallinn University of Technology will defend the position against. To confirm, the arbitration offers a more efficient and impartial alternative to lengthy and costly state-to-state dispute resolution, will be argued by University of Manitoba, and Tallinn University of Technology will argue that arbitration does not offer a more efficient and impartial alternative to lengthy and costly state-to-state dispute resolutions. You will now have 5 minutes to finalize your preparations. You can close your cameras and we'll go live with the position in favor once the timer is up. Great. Thank you very much. Your time for final preparation is now over. So we'll be starting with the position in favor. So the debate team of University of Manitoba will start. You will have 4 minutes. For the timekeeping, please look at the video stream from my colleague. So yellow card signalizes 30 seconds left. Red card signalizes your time is up. So without further ado, University of Manitoba, you have now 4 minutes.
Good afternoon and evening, judges, and to our friends from Estonia and anyone watching. Thank you for joining us in this debate today. I will start by going over some modeling of this motion and get into our first two constructive arguments. In terms of modeling and definitions for this round, there are a few areas we on the affirmative side would like to emphasize. We define arbitration as dispute resolutions done in the Permanent Court of Arbitration in The Hague. We define state-to-state dispute resolutions as state-to-state conflict and not investor or commercial arbitration resolutions. Lastly, in terms of modeling and defining, we want to recognize that through this motion, we are excluding interstate conflicts relating to jus cogens violations, such as genocide, slavery, crimes against humanity, or other intentionally criminal acts, as we believe arbitration or negotiating of any sort on this would set an immoral and disturbing precedent. Now let's get into it. We're going to do 3 arguments today. Firstly, we're going to talk about why arbitration offers a timelier process of resolution. Second, we will outline how the process of the adversarial system isn't conducive to states and their sovereignty. Lastly, arbitration will increase buy-in from other states. First, arbitration offers a timelier process of resolution. Fundamental principle of international law, as noted in Article 1 of the UN Charter, is to protect freedom and promote peace amongst nations. Tool to maintain that peace and freedom is by providing resolutions on international disputes. However, the current process is inefficient and not done in a timely manner. Evidence of this can be seen through the fact that since 1947 to the present, the ICJ has dealt with and provided decisions on a grand total of 192 cases in 76 years. This is an average of 2 cases per year that the ICJ decides on. However, on the international stage, I can assure you there are far more than 2 international disputes every year in need of a resolution. This is where states have already began using arbitration, as it is much more timeliness and it's much more efficient than the adversarial system. Furthermore, the process of arbitration can be more efficient as it does not involve waiting for a decision from an adversarial system or delineating between right and wrong. Arbitration is not a black and white or right and wrong, but rather allows nation states to compromise, give and take into finding an effective solution to pressing matters. This leads right into our second argument, that the adversarial system is not conducive to states. Judgments delivered by international courts can often be neglected by nation states if they disagree with the outcome of the proceedings. An example of this can be seen in 2018 when the United States rejected an International Court of Justice ruling mandating that U.S. sanctions allow exemptions for exports of humanitarian and civil aviation supplies to Iran, because they believed this decision wasn't fairly aligned with their national interests at the time. Now, understanding this example and the nature of arbitration, the goal is justice and peace. Arbitration does this more effectively in 2 ways and more conducive for 2 reasons. Firstly, the issue with the adversarial decisions you get is black and white, winner takes all. This alienates nations who lose, and due to there being no enforceability of decisions, states can refuse the decisions. Most of the time, these resolutions are about preventing turmoil and escalation, and the goal is not to have a winner or loser, but much rather a compromise. Therefore, you are in a much better place getting buy-in from both parties in a give and take, and arbitration provides this. Second reason why it's more conducive to states is there are a lot of international concerns between states that just go beyond the law. Things that you cannot bring up in an international court proceeding or states cannot say in formal settings. Arbitration allows states to be more candid. For example, in that last example, the US probably doesn't mind providing aviation aid to Iran in the circumstance, but due to other international tensions on other matters, they refuse. Perhaps the Iran government is selling arms to a nation the US doesn't like or wants prisoners released. Arbitration provides an informal setting nations can address these concerns in and compromise that you wouldn't normally get in a formalized court setting. This would also align with both interests and more likely to have follow through from both nations. It is for all of these reasons we are proud to affirm this resolution.
Thank you very much. This concludes your opening statement. The opening statement in the position against the debate team of Tallinn University of Technology. You now have 4 minutes.
Thank you very much. Good afternoon, distinguished panel of judges and honorable guests, and also the team of the University of Manitoba. My colleague Xenia and I are excited to continue this debate. First of all, how easy is it for you to agree on the custody of your dog with your ex? Right? It's not that easy because you need an agreement for this. And similarly, you need an agreement for arbitration. And that is why we don't believe that arbitration does not offer a more efficient and impartial alternative to traditional state-to-state dispute resolutions. Because one, it is difficult to find harmony in conflict, and two, it is very difficult to find neutral arbitrators, and three, the question of enforceability. So first of all, the difficulty of finding harmony in a conflict. As I already said, arbitration is built on agreement. And therefore we have a case that is Myanmar against Bangladesh about the Bay of Bengal. And there they struggle to agree on the rules of arbitration, the selection of the arbitrators, the jurisdiction of the arbitration tribunal, and the interpretation of international law and treaties, which therefore hindered the whole process. This led to the failure to reach a consensus, which therefore prolonged the tensions and the periodic flare-ups in the disputed area. The result of this was that the dispute was not resolved through arbitration, but it was resolved through the International Tribunal of the Law of the Sea in 2012. Therefore, this shows that it does not offer an effective alternative to state-to-state dispute resolution. Second, the impossibility to find neutral arbitrators, because right now we have a very polarized world. We are standing basically NATO to CSTO, authoritarian against democratic. This is also shown in the case of Israel against Palestine, because there's the problem of finding any neutral person, because every country has taken a side, either Palestine or Israel, as you can see by certain countries banning certain demonstrations. For example, France is banning pro-Palestine demonstrations. Other countries do the same for Israel. And therefore, it is hard to find a neutral arbitrator because they don't want to go against the prominent position of their state. And this lack of perceived fairness results in further exacerbation of the tensions and hinders the prospect of finding a sustainable resolution. And our third point is the question of enforceability. Enforceability is a crucial part which arbitration lacks. In the UN Charter, which the ICJ is built on, it is a customary international law which is binding for everyone. This does not include, or that does not mean for treaties and agreements, because they are only binding for the parties that are signed to it. And you can easily go around this, because when you look at Venezuela, for example, they avoided the responsibility of an award given to them by the ICID, which does not ensure the mechanism to enforce. And the only exception to the international voluntarism is the Security Council, and this is part of the ICJ. The Security Council ensures the enforcement in Article 94.2. It even offers the option to use force. And also the court, the International Court of Justice, has prestige and allows other. Therefore, we disagree that arbitration offers a good alternative to state-to-state dispute resolutions. Thank you very much.
Thank you very much. This concludes the opening statements for both teams. We are now opening the rebuttals. Starting with the debating team of University of Manitoba, you have 2 minutes for your first rebuttal.
Hi there, just confirming that you can still hear me, and thank you again for allowing us this opportunity to continue debate. We would like to rebut the proposition that it is not possible for arbitration rulings to be binding or authoritative in an international context. Between states where there's multiple political, social, and economic considerations that lead to ongoing conflicts, it is often the case that states are unwilling or unable to appreciate how to come to a compromise on an effective manner, and these disputes can last for an extremely long time. For example, similar to the position that was adopted by the Tallinn University, we would point to the agreement between Bangladesh and India over a maritime boundary dispute that resulted from 1947 when the countries are partitioned. This dispute was heightened in the early 1970s when changes to geological features created uncertainty in the border, and also when there was the possibility for offshore development of oil and gas resources that both countries were seeking to exploit and auction off to international companies. Under this uncertainty, Bangladesh commenced arbitration proceedings in 2009, and by 2014, the arbitration tribunal had determined the maritime boundary in a fair and impartial manner. More importantly, both parties were content and were willing to celebrate and uphold that ruling, and as a result, both parties have been able to clearly delineate and exploit their economic opportunities in a basis and in a way that they would not have been able to just by communicating and resolving dispute by themselves. The proceedings took only 5 years, but these 5 years are insignificant with respect to the almost 60 years of non-agreement, dispute, and conflict between these parties before the arbitration began. In this context, arbitration, we believe, clearly offers a more efficient and cost-effective manner of resolving disputes in an international context. States are often unwilling or unable to resolve disputes themselves, and this is where arbitration is essential.
Thank you very much. Now for the first rebuttal of the Tallinn University of Technology, you have 2 minutes. Your microphone is muted. Please restart whenever you're ready.
All right, now confirm that you hear me.
Yes.
Thank you again for the team of Manitoba for providing your arguments. However, we would like to point out a few inconsistencies and weaknesses in them, which prove that arbitration is not an efficient way of resolving state-to-state disputes. First of all, you have mentioned some arguments in relation to timing of the resolving of disputes. ICJ has as you mentioned as well, a proven record of cases that were successfully dealt with. For example, the ones that we've mentioned before, as in Myanmar and Bangladesh, as well as territorial maritime dispute between Nicaragua and Colombia, which was successfully resolved in 2012 by the resolution of the by ICJ, as well as the frontier dispute between Burkina Faso and Mali on the over the common border that they have. In the beginning, that dispute was tried to be negotiated between the states. However, they could not come up with the pre-arbitration rules, and therefore it was led to ICJ, which resolved this issue. As you mentioned yourself before, the compromises are hard to achieve and it can take a long time to do so. Therefore, we believe that ICJ and other tribunals and courts of justice that are made for that nowadays supposed to be the ones to resolve these issues primarily and not arbitration. You also mentioned the enforcement possibilities, but we believe that enforcement rules, as we proved before by the Venezuela issue, is also better proven by with the Security Council to enforce it through the regular system of dispute resolutions. Thank you.
Thank you very much. For the second rebuttal, University of Manitoba, you have 2 minutes.
Hello, am I audible?
Yes, with an echo. Please try again.
So, thank you for your points to our opponents, but I have to disagree with your argument about the timeliness of the ICJ versus the PCA. The quick turnaround time that arbitration offers makes it preferable to any other method of resolving state-to-state disputes. As my co-counsel mentioned in our opening statement, the dispute over land boundaries in Bangladesh is a prime example of how arbitration can expedite a process that took decades when states attempted to solve it using other methods. When states choose to solve issues without binding third-party intervention, they can drag on for years. Take, for example, the dispute between Guyana and Suriname over territorial boundaries related to the division of the Corentyne River. This dispute dates back to colonial times. The first recorded discussion about where the border was dates back to 1799. Disputes over the location of the border continued for centuries, through both countries gaining independence from their respective colonizers and into the 21st century. The dispute culminated in the early 2000s when the operations of multinational petroleum exploration rigs were interrupted by patrols who claimed they were violating territorial boundaries. In 2004, after some 200-odd years of disagreements, Guyana initiated an arbitration process with Suriname through the Permanent Arbitration Court. In 2007, the tribunal rendered their decision, and both parties, as they had originally agreed to be, were bound by it. The arbitration process accomplished in 3 years what before had been contested for 2 centuries. With expediency comes decreased costs, and decreased costs are very important when states are deciding how to resolve conflict. Costs arise both in the process itself and also in economic loss incurred by countries who are unable to participate in economic activity in the region where sovereignty is disputed. In the Corentyne River dispute, both Guyana and Suriname were not able to exploit natural resources in the region due to territorial disputes. Once the arbitration process delineated the boundary, Guyana was able to make use of the resources that were no longer under dispute and to benefit from them economically. As this example demonstrates, arbitration is much more effective than the adversarial system when states want to solve territorial issues in an expedient manner. Finally, in terms of peace and harmony, it's much more effective to arbitrate because, as my colleague said, states are not actually bound by other processes as well. Thank you for your time.
Thank you very much. For the second rebuttal, Tallinn University of Technology, you have 2 minutes.
I'd just like to confirm that I'm audible.
Yes, you are.
Thank you very much. Thank you for providing your rebuttal. I would like to go on to some topics that you mentioned. First of all, I would like to agree that you said that it takes a long time to find an agreement, as you mentioned that. So that's also the biggest problem of arbitration, finding that agreement, and this can also take decades and very long time. Whereas when you go to the ICJ, you already have that agreement and you're good to go. This can be seen by the US-Iran tribunals that you also mentioned, because many of those cases have not yet been solved, and which shows a lack of efficiency, and also what you mentioned about peace and harmony. The two countries are still not very fond of each other. They don't have good diplomatic relations. Right. And also you mentioned the decreasing of costs, which again, you have not, we believe that you as a team have not fairly proven that arbitration is indeed faster than going through the ICJ. Which then, a faster route would mean less cost. But again, we have not yet seen a proof that the ICJ is indeed slower in this, because as I already mentioned, finding an agreement in the beginning to start an arbitration takes a long time, right? And this is why we believe that arbitration does not offer a more efficient and impartial alternative to our. Thank you very much.
Thank you very much. This marks the end of rebuttals, and we are now in conclusion. University of Manitoba debate team, you have 2 minutes for yours.
Hello, everyone. Thank you again for holding this debate today. I would like to reformulate our propositions and reaffirm our support for arbitration as being the most efficient and cost-effective form of dispute resolution as compared to state-to-state disputes through any other form, including the ICJ. We agree with the proposition listed by the Tallinn University that it's difficult to find agreement in conflict, but it's not difficult to find agreement in peace. When states signed on to the UN Convention of the Laws of the Seas or any other contractual or investment treaty, they already build in dispute and arbitration proceedings within the very terms of the contract, which reaffirms the value, efficiency, and essential nature of arbitration to resolve any disputes that may come up between parties. In terms of impartiality, we find that arbitration offers a more neutral environment for states to air out and discuss their issues, whereas the ICJ, in its terms, requires criminal proceedings of a charge that has been impugned or an action that is seen to be in violation. Arbitration allows each party to nominate one arbitrator for themselves, one arbitrator for the other side, and those arbitrators appoint a neutral arbitrator to chair the tribunal. It's hard to imagine any other form of international proceeding that allows both parties to be on such an equal footing. Lastly, while we agree and we do concede that it is hard to find binding effect on arbitration agreements, it is much more difficult for states' resolutions to find binding effect. There's nothing compelling states, once they made an agreement, to continue upholding that agreement. As a last example, I'd point to the Memorandum of Understanding that the Russian government and the Ukrainian government made upon the dissolution of the USSR, where the Russians promised to respect the sovereignty of Ukraine in exchange for Ukraine returning nuclear assembly vehicles and nuclear weapons back to Russia. As we have seen in the present day, that Memorandum of Understanding has not been fulfilled. Thank you for my time.
Thank you very much. For the conclusion and the against position, University of Tallinn University of Technology debate team, you have 2 minutes.
Thank you. So to sum up our today's debate with the opposing team, the question of arbitration has been a more effective alternative to a judicial settlement mechanism. We have demonstrated beyond doubt that arbitration has issues when it comes to achieving consensus on the rules of arbitration, which make it less efficient. Moreover, it is extremely hard to find impartial arbiters in our today's polarized world. And finally, it lacks in the term of enforceability. Furthermore, we have efficiently rebutted the arguments of the opposing team, exposing weaknesses in their reasoning. Those include, especially the question of the enforcement of ICJ, which is proving to be one of the most sufficient by, for example, the only existing nowadays proven track of security counselor, which can enforce resolution of the disputes without the agreement of people, of states, which we both agreed that is hard to agree within states and it can take a long time. Additionally, we provided a number of cases that prove the long history of successful work of ICJ and other tribunals that exist today and that exist for this very reason of resolving today's disputes. In conclusion, we believe that we sufficiently proven that arbitration does not offer a more efficient way of resolving state-to-state disputes. Thank you very much.
Thank you very much. This now marks the end of your debate session. You are no longer graded. You can turn your cameras back on. You can relax, take a sip of water. I will be passing the floor to my colleague who will walk you through the feedback session and then a bit of networking at the end. But really, well done to both teams. And I pass the floor now.
Yes, many thanks and well done for your debate. I was listening to everything and indeed it was quite rich in terms of argumentation, I have to say. Now it is time to collect your impressions from the argumentation of both teams, as well as the preparation for this topic. And as well, yes, just in general, what you thought about your performance as well, and the performance of the other team. We start with Mr. Samir Harris. What did you think about this match?
Oh, I truly enjoyed it. It was really a pleasure to be here. I don't have any background when it comes to international law, so it was a lot of fun and also very challenging experience researching and preparing for this debate. But I think for me personally, I had a worthwhile experience, and it was really good to hear both sides of the argument, including preparing both sides of the argument in advance.
Thank you very much. Now in Tallinn, Ksenia Rikasheva, what did you think about this match?
Yes, I totally agree. I really enjoyed it, and just wanted to point out that I'm surprised that you've mentioned that it's you don't have experience in international law, because it didn't sound like that for us. Yes, it was indeed interesting to prepare for both sides. It was quite hard for us to prepare for the against side, to be honest. So we are really happy with our results. Thank you very much.
Thank you. Many thanks. Now we have as well Tia Andrews. What did you think about this match?
I really enjoyed it. I've never done any formal debate before, and it's something I've wanted to do since I was in middle school. So it's been a really cool experience for me to be able to, test my mettle against you guys from Estonia, and you didn't make it easy. So thank you for that. And I'm excited to move forward through the tournament and continue and try to see how else it goes and meet some more people. And, thank you guys for participating with us. It was very nice to meet you guys and argue against you. And thank you to the organizers.
Thank you, many thanks. Now back in Estonia, Fabienne Lucigol.
Yeah, I can just agree with everyone. It was a lot of fun doing this debate with, especially Xenia, preparing everything and going through a lot of case law. So it was a good ride. Yeah, I can't say that much more, to be honest. It was good. You were good competitors, and
Thank you, many thanks. As well, Kirat Boulard. What did you think?
Hi. I had a really great time doing that. That was a great practice of advocacy skills, something that's really important to all of us. I found that it was quite challenging to do some research on the topic, and then it was also good to work together with a team, something that's nice practice on. And to our friends from Estonia, that was a very well done speeches. We had a great time going back and forth with them, and to the organizers as well. This is a great opportunity for us to practice our advocacy skills.
Thank you, many thanks. Now I give the floor to one of the coaches who is in the room, Ms. Gutierrez. What do you think about the performance of both teams tonight and this afternoon in Canada?
Well, thank you. Congratulations to everybody on getting another match under your belt. I thought both of the teams did a wonderful job. You can really tell how much preparation went into all of this by virtue of the several cases that you were able to pull out, the legislation you were able to refer to, and how you were able to respond to each other based on those general principles that you're arguing on. Everybody did it amazing. Great poise and eye contact on the whole, and just good luck with the rest of your rounds and keep up the good work.
Thank you, many thanks. So I think, yes, for the time being, of course, the three judges will be watching this match thoroughly. As I already mentioned, so we're on Monday. You can expect around the second part of this week to see the results. So greetings to the three judges who will be watching the match. One is in Africa, one is in UK, one is in Croatia. So these judges will be watching the match. They don't know each other, by the way. So now, moving to the last part of this session, I will ask each of you, because as well we have to mention that it is the first match for the team from Manitoba. This is the second match for the team of Tallinn. Tallinn have this second match already met the third university of this group, because there are three universities in this group, which is the University of Lagos. Lagos doesn't have a match at this moment, but in 2 weeks it will be the turn of the University of Manitoba to have a match against the team from the University of Lagos. So, as it is the first time we hear the team from Manitoba, maybe it would be good to ask them first to present their university. Could you present your university to tell what you can study, as well, the different fields of law maybe which are available as well, and just to know in general what to keep in mind about this university in Winnipeg.
Hi there. Yes, I can speak a little bit about the university. The University of Manitoba is the oldest university in Western Canada. I believe it was founded in 1877. And as a result, it's got a very rich body of legal education and legal instructors. We have quite a lot of opportunities, especially we have a Master's of Human Rights Law, International Human Rights Law program available. It is in Winnipeg, as you correctly noted, and one of my favorite things to do here is that in Winnipeg we have these two rivers that are connected to each other, and in the wintertime you can skate for multiple kilometers on the river. It's a lot of fun. Okay. That's all I have to say about Manitoba, I guess.
Thank you. How would you present your university, THIULDT, to the students from Manitoba?
So yeah, of course, we can talk a little bit about the university. As I understood that the Positive studies are the Canadian law, I believe. Like here, we study international European law program. It's in English, and we have different laws there. But because it's studying University of Technology, there's a big specialization in cybersecurity and data protection. So we are a bit sad that we will not participate in the first competition that would be inter IT law. But for us, it was interesting to compete in something that is usually not taught for us as in depth. However, we are personally I'm really interested in. For example, the human rights is a really big thing for me. And the Tallinn, yeah, I mean, it's a really cozy town, city. It's the capital of our country, this country. And especially during Christmas, I think it's really beautiful to visit. So come to visit.
Thank you very much. I have a question for the students of Manitoba. Do you know what has been invented, which is very famous, in Estonia?
Sorry, no, we're not too sure what the most famous thing invented is. I'm so sorry. I feel like we're offending you guys.
No, not at all. No, it is something which is connected to internet, more or less. Yes, no?
Oh, was it a Skype?
Yeah, yes, indeed. So how did you know that? Someone told you, or?
No, when you mentioned internet, that was like one of the first things that came to my mind of like old webcamming.
Yes, indeed. And now, what is famous? I mean, pretty famous in the world, which is coming from, I mean, Manitoba, or let's say, is famous from Manitoba particularly, from Winnipeg even.
You have to answer.
Yes.
Good
We're supposed
question.
we don't want to like we want to be polite and nice. We heard a lot about Canada, but to be honest, until this day, we were not sure how to pronounce Manitoba, and you. But it's really that's why it's really an interesting opportunity for us to see someone from a place that we've never heard about. But we believe that is really interesting, just a bit far away from us. So sorry,
Yes.
but we're really interested what is there. So tell us, please.
So for the students from Canada, is it true that it's possible to see polar bear in Manitoba or not?
Yes, it is very possible. If you go up north, so Manitoba is a very long province from north to south, and you have to take a train, like a light rail train, all the way up to a place called Churchill, which is on the Hudson's Bay. And you can do these tours where you go out in these like large all-terrain armored vehicles, and the polar bears will like climb on the vehicles, and you can see them through the glass. You can also see beluga whales and Arctic foxes and the northern lights. Do you guys have the northern lights in Estonia? Is that pretty common? Nice. They're really awesome.
We actually have seen them yesterday.
Oh. No, yes, I guess it depends on the period as well. When it is possible to view them over Scandinavia, like in Baltic as well, it's a different period in Canada. You can watch them, but within the same year. Huh? But I think in Iceland it is in April. You can see them as well. So yeah, okay, good to know. So. One thing, very last question maybe, what you would like to do after your legal studies, after finishing your studies? Do you have in mind a job, a career already? So very quickly, for example, a Miss Goal, what do you want to do after you finish your studies?
All right, so as I'm a first year student, I have not thought out everything yet, but I would like to focus on technology law. That's why I'm also here, but that would be my way of doing a master's and all that, but mainly focusing on technology law. And I know that Xenia, for example, will want to focus on humanitarian law.
Mhm.
So there's a lot of options still in a university that focuses on technology.
Okay, very good. In Canada, Mr. Harris?
Sorry, I was still on mute. For myself personally, I'm hoping to work in another large Canadian city as in a business law firm, hopefully with a litigation practice. I like to speak and to be on my feet and think really quickly. So I'm hoping that the internships I have lined up will lead to a career in that line of work in the future.
Okay, very good. Miss Andrews?
Our faculty does a fantastic job of exposing us to all different areas of practice. And because of this, I've had a lot of trouble deciding which one interests me the most because I didn't go in to law school knowing what I wanted to practice. This week, I've already had an interview with a Manitoba Prosecution Services, so like within the criminal justice sector. I've had an interview with an IP law firm that does like child protective stuff online. And then I've had an interview with like a corporate commercial firm that does wealth management. So it's interesting that here we have the opportunity to kind of go and be summer students in those different areas. So short answer, I'm not sure yet, but I'm very excited to figure it out.
Okay, very good. Very good perspectives. And then Kirat Bular?
Yeah, for myself, I'm completely undecided still. I no set mind. I would like to do something with advocacy though, perhaps maybe in the criminal defense realm, but I'm not too sure yet.
Okay. So the last word to Miss Rika Cheva is humanitarian law on your side, right?
Not exactly.
Sorry. Okay.
I'm not completely sure which side of international law, but I had some experience of taking courses in The Hague for the international criminal justice, which was extremely interesting. So that's why I was also keen on to do this debate for the National Court of Justice, because I've seen it. But so that's why I actually do believe in this system. Human rights also sounds really great, and this is my last year of bachelor's, so I'm right now actually currently applying for master's. I think Canada sounds great.
Yeah.
I don't know.
So it's exactly what I wanted to tell. To keep contact between the two teams, of course. I mean, because this is a match, it's an opportunity, of course, to keep contact as well after, because you never know to have an expert in one field or in another, and as well from those countries as well. I mean, from Europe, from Canada. So yes, don't hesitate if you want, of course, to keep contact, to ask the foundation. We'll put you in contact this way. And what I want to say as well is, of course, congratulations again. This is the end of this session. You'll receive the results in a few days. And I wish you the best for the rest of the week, of course. So many thanks in Canada, many thanks in Estonia. And well done again. Thank you. Bye-bye.